It is a terrifying prospect that instead of this government dealing with the reasons people are upset about the rate of illegal migration, asylum seekers in hotels, thus resulting in protests across the country, they are reportedly setting up an elite police squad to monitor anti-migrant posts on social media. So I'll come back to the article in a minute and I'll link it below, but let's get this straight. Instead of actually dealing with the root cause of these issues, they are setting up an elite police squad with what limited funds they must have for the police, because there are vast numbers of crimes that go uninvestigated because they haven't got the time, resources, and etc. They are setting up an elite police squad to monitor anti-migrant posts on social media. But to what end? Is that so they can hunt people down and charge them with an offence? Because the law on free speech is actually very strong. Now, I've seen a number of videos, which I'm not going to comment on because some of them have resulted in arrest, so I won't comment on any specific video. But what I will tell you very broadly is that unless your speech and your exercise of the right to the freedom of expression, which is more than just speech, by the way, but it incorporates speech, unless that is outright criminal, which is a fairly high threshold to pass, then you have every right to do that. And I will cover much of that law in a minute, not as legal advice, but something that many people might want to bookmark, share with somebody, and come back to later, because this has been upheld in court time and time again. Now, I will give you the Balancing Act, and I won't tell you whether I believe it or not, and I won't tell you to believe it or not, but the Balancing Act, I at least hope, is this. If they are setting up this elite police squad to monitor social activity for anti-migrant posts, then I sincerely hope that it is with the sole aim to get ahead of any would-be violent disorder arising out of civil unrest. And civil unrest meaning it's broken out of being a civil protest and it's moving into a violent disorder of sorts. And so they can get ahead of that and prevent it from happening, prevent buildings being damaged, prevent businesses being harmed by it, prevent people being harmed by it. And of course, I accept fully to prevent any harm coming to any of those hotels and anybody in those hotels, because of course that would be wrong. Many people have been to prison for inciting such violence. And so that, of course, is wrong. So I can only hope that this squad is to get ahead of any of that and prevent it from happening, because I certainly would not like this to be followed up with a whole host of prosecutions for people exercising their right to the freedom of expression online. That caveat said, let's come to this article and see what it says. It says detectives will be drawn from forces across the country, like they haven't got anything better to do, to take part in new investigations unit that will flag up early signs of potential civil unrest. Now, as I said, I'll refer to my caveat through this video because I really hope that the purpose is to prevent civil unrest and to prevent violent disorder. That is certainly how the article reads thus far. That is certainly how I would like it to be. But I do have a feeling that this is ripe for abuse. But that said, I hope that it isn't. It says the division here, assembled by the Home Office, will aim to maximise social media intelligence, which in one sense is a good thing so long as they're not chasing down prosecutions just for saying something online. So they aim to maximise social media intelligence gathering after the police forces were criticised over their response to last year's riots. Now again, with the Balancing Act, the police last year were criticised for not knowing what was happening, not getting ahead of it, and so now you might argue, well, they are at least doing something to be familiar with what's going on, get ahead of what's going on, and ideally nip it in the bud before it actually gets too far. All of which, on the face of it, sounds reasonable because crowds are gathering in towns and cities across the country, and there's a growing concern that there's going to be more disorder and so on because people are genuinely upset, of course. However, as you can probably tell by the concern I show in the video, is that there are two sides to this. One is that hopefully they use this only to prevent disorder. The other is it might be abused by arresting people just for the exercise of free speech. For example, if some local forces misunderstand what this is for, or they take it to mean that what they've said is somehow unlawful, which in the vast, vast majority of cases it won't be. In some, it will, of course. If you get the odd person that says, you know, we should go and do this, and this means something which is out of a civil setting, more than just civil protest, then of course that is going to be investigated by the police. So I would urge anybody watching, however frustrated you are, not to make those kind of posts that are encouraging or inciting any kind of violence, any kind of disorder at all. But, like I said, I hope that that's where it ends, and I hope that's the limit of it. Nonetheless, it's attracted criticism. Chris Philp, Shadow Home Secretary, has said, two-tier Keir can't police the streets, so he's trying to police opinions instead. They're setting up a central team to monitor what you post, what you share, what you think, because deep down they know the public won't buy what they're selling. Don't buy what they're selling, excuse me. He says, Labour have stopped pretending to fix Britain and started trying to mute it. Now, we've seen this with the Online Safety Act. Now, it is supposed to be, as I explained in my other video, it is supposed to be to protect children from harm, from harmful content, and so on and so forth. However, there's been widespread reports, some of which I'm yet to really validate, but widespread reports that certain posts and certain websites and all sorts of stuff are being limited because of this Online Safety Act, and you have to verify your ID. Obviously, then you need a passport or driving license, Face ID, and everything else, which people don't want to share, which is why there's been a massive spike in VPN sales. This video is not sponsored, but if you do want 4 months free off NordVPN, I'll put the link below because it's a great deal. I use NordVPN all the time. This is not a sponsored video. I genuinely use it myself, which is why I partner with them. I'm very careful with who I partner with. But this is a devastating effect on free speech. If that is what's happening with the Online Safety Act, and hence my fears about this little squad monitoring what you post, which may be unlawful. Because if we remember, if I jump across with this case here, this was Miller and College of Policing. This was about the non-crime hate incidents. There's sort of a blanket policy of monitoring and then recording non-crime hate incidents against people without their knowledge, without any facts and real basis or proof of a crime, and no crime at all, in fact, just somebody's perceived harm, even though it's just one individual, and it may not be the purported victim. It could be anyone perceiving any kind of harm through anything that somebody has done, and that person then has a non-crime hate incident recorded against them by the police. The court effectively said that the way that they were doing it was unlawful. And it says here, the bit in highlight, it says, these revisions, with a greater emphasis on proportionality, appear to be designed to meet the criticisms made of the police conduct, as it could be said that at the very least they demonstrate there was a scope for less intrusive means. But, in my opinion, they do not go very far, or not nearly far enough, to address the chilling effect of perception-based recording more generally. So my fear, of course, because this made its way to court, my fear is that these kind of things, this kind of monitoring is going to end up just like this, and cases that, I mean, this case went to the Court of Appeal. This Miller and College of Policing ended up in the Court of Appeal. Are we going to end up with people being prosecuted and then having to go through the whole process, which takes years and funding, to challenge these things and go right up to the Court of Appeal? I nearly said Supreme Court, because it probably will end up in the Supreme Court at some stage, as to what the extent of the freedom of expression is. Back to the quotes. Chris Philp goes on to say, this is a Prime Minister who's happy to turn Britain into a surveillance state, but won't deport foreign criminals, won't patrol high streets, won't fund frontline policing, which is absolutely the point. We really should have frontline policing. That is the big deterrent. I remember being young, you wouldn't go in more than a couple of streets without seeing a police officer, and everybody kept themselves in check because they knew that they would be sorted. Chris Philp says, Labour's scared of the public. Labour don't trust the public. Labour don't even know the public. And I would somewhat agree. I get the feeling that they genuinely don't understand the general feeling of the public as it stands today. Nigel Farage says, this is the beginning of the state controlling free speech. It's sinister, dangerous, must be fought. Reform will do just that. And the article goes on. I'll link it below. But what I wanted to do in this video is to compare and contrast that. I'll also link, by the way, Susan Hall's video here, where she gives her thoughts on exactly this and what's going on, because I think they're all worth reading. But what I'd like to do for you in this video is go over a couple of cases and outline the framework. And I'd like to start with Scotto and the CPS judgment here, whereby Scotto and the CPS, it was all about malicious communications prosecution back in 2020. And in essence, this paragraph sums it up perfectly. The judge said here, the prosecution argument failed entirely to acknowledge the well-established proposition that free speech encompasses the right to offend and indeed abuse another. The judge appears to have considered that a criminal conviction was merited on acts of unkindness and calling others names, and that such acts could be only justified if there was a contribution to a proper debate. So the court confirms here that you have the right to not just offend somebody else, but to abuse somebody else, providing it doesn't cross the grossly offensive threshold to make it criminal. And of course, a course of conduct more than one occasion, on at least 2 occasions, may then become harassment. So that is free speech. But then we can come to this case as well, which made its way to the High Court last year. And this very neatly outlines the framework for free speech, the freedom of speech, in particular, free speech and the prohibition on propaganda. So there's a legal framework here set out. Now, many people think that if we leave ECHR, we lose the right to the freedom of expression. This is patently untrue, because free speech, as outlined here, is a fundamental common law right. This was confirmed in 2002 per Lord Bingham's ruling. It's been described as a primary right, without which the effective rule of law is not possible. It's the lifeblood of democracy and a brake on the abuse of power by public officials. It's had all sorts of different descriptions here. Even George Orwell down here. If liberty means anything at all, it means the right to tell people what they don't want to hear. And one of my favourite quotes here of Voltaire, "I disapprove of what you say, but I will defend to the death your right to say it." All recognised as free speech. Now, interestingly, in the case of Shaler, Lord Bingham said as follows: "Modern democratic government means government of the people, by the people, for the people. But there can be no government by the people if they are ignorant of the issues to be resolved." All pertinent to this video. The arguments for and against different solutions and the facts underlying those arguments. The business of government is not an activity about which only those professionally engaged are entitled to receive information and express opinions. It is, or should be, a participatory process. But there can be no assurance that government is carried out for the people unless the facts are made known, the issues publicly ventilated. And then it goes on here in this judgment to say, genuine political dissent is therefore afforded strong legal protection. So any government policy, anything that is ultimately a public law decision by a public body, not only is judicially reviewable, but also under this judgment is genuine political dissent and discussion, and therefore afforded strong legal protection. And it separates various categories here and describes. I won't go through them all, but here are some of them. Of course, the first one, speeches made during parliamentary proceedings and papers distributed in the course of parliamentary proceedings are subject to absolute legal immunity. The principle there is if you are an MP, you're in Parliament, you can absolutely say whatever you think is right and necessary in Parliament and has absolute legal immunity. Secondly, interference with the freedom of expression of opposition politicians call for the closest scrutiny of the part of the court. Thirdly, in this context, the law protects not just against direct interference with free speech, but also indirect chilling effect of deterring others from exercising their right to free speech. Fourthly, the role of the press to act as a public watchdog in imparting information and ideas. This all flies in the face, really, of the Online Safety Act if they are cutting access to certain things. And just as an aside, I'll stop screen sharing for a moment. One point very well made by someone yesterday, I think, said, on the one hand, the government wants to give the vote to people that are 16 years of age. However, if they are not 18 years of age, thus cannot verify their identity as being 18 years of age, and thus prevented from seeing certain posts online, how on earth are they going to have all the information with which to make an informed decision for whom to vote in the next election? Valid point, I thought, well made. Moving on. Number 5. In Sims, the Secretary of State sought to restrict the ability of a journalist to interview prisoners who maintained that they'd been wrongly convicted. Lord Steen said the prisoners are in prison because they're presumed to have been properly convicted. They wish to challenge the safety of their convictions. In principle, it is not easy to conceive of a more important function with which free speech might fulfill. In English, it means if you're in prison because you've been convicted and you want to speak to the journalists because you believe you've been wrongly convicted and both convey and receive and impart information, free speech should absolutely prevail. Number 6. Even where free speech is defamatory of another person, contains a false statement of fact, qualified privilege might attach. Qualified privilege could be, for example, matters of public interest and so on. Furthermore, number 7, and this is probably the key one that I'll leave you with here in this video, which everyone should take a note of. Please bookmark the video, share it with somebody, screenshot it, do what you like. Not legal advice, but absolutely fundamentally important that people hold on to. Number 7, for the same reasons, a similarly high level of protection can in principle also extend to responsible citizen journalists and bloggers and popular users of social media, although it is necessary to recognize that the risk of harm posed by content and communication on the internet is higher than posed by the press. Forgive me, I will read one more out at number 9 in the case of DPP and Manchester City Magistrates Court. DPP appealed against the acquittals of 2 protesters of public order offences. They shouted "Tory scum" and intended and did cause alarm. The Divisional Court upheld the judge's finding that the defendants had a defence of reasonable conduct. In such cases, the court said here, the court has an important role as the constitutional guardian of the freedom of political debate, and thus as a trustee of our democratic framework. And so, to reiterate, the DPP appealed because 2 defendants were acquitted for shouting "Tory scum," intending and causing alarm. But the judge at the Divisional Court upheld their defence of reasonable conduct. And so, to summarise, I hope it goes without saying that I hope there is no more civil unrest. I hope there is no more violent disorder. I hope people don't make those comments and don't incite violence and don't incite hatred and so on, because you will come unstuck for it, so please don't do that. But at the same time, please do take heed of the lessons of law, if you like. I am just conveying the law to you here. I'm not some kind of genius. I just have access to the law. I've been taught to understand the law and I can convey the law to you. Hopefully it's useful to you. If it is, share the video with somebody, like the video, subscribe to the channel, please. About half of you don't do that. I'd really appreciate it if you did. You never know, you may rely on some of the content in these videos at some stage. It isn't legal advice because I'm not sitting down with you and going through the facts of whatever particular case you've got, but it can absolutely help you. I know, humbly, I know that it has helped a lot of people over the last 5 years. People have emailed in and been absolutely ecstatic that they've won their case because they've used 1 or 2 tips and tricks through my videos, and I'm really grateful for that. If it's helped you in any way whatsoever, or you want me to keep fighting this fight for free speech here on this channel, please do subscribe, and I'll see you next time.